Welcome back, folks. I'm Aaron Keller with the LawNewz Network, and I'm here with attorney Julie Rendelman. We're listening to replays of some of the greatest hits in the Aaron Hernandez double murder case and discussing some of the additional instructions that the judge gave to the jury this morning about this intimidation of a witness charge. And we're trying to go through some of the jury instructions here to make a little bit more sense of it. So thoughts initially on what this means and where they're going?
My viewpoint is that this is good for the prosecution. I think that if they're deciding whether or not Aaron Hernandez shot Alexander Bradley directly or indirectly regarding the initial shooting, indicates to me at least that they think that Aaron Hernandez did the initial shooting, or why would they even care about the second prong of this case?
Yeah, let's go back and listen, if we can, to the clip of the judge explaining this instruction again this morning, because it'll put, we don't have it yet, so we can't do that. But basically the instruction was that the only evidence presented in this case was that of a direct physical injury at the hands of Aaron Hernandez, and again, it just boils down to whether or not the jury wants to believe Alexander Bradley. But I went through the model jury instructions. I'm not sure if they're the ones that were actually read to the jury, but the model jury instructions have three elements for this crime. The first one is that, and the jury could find this if they weed through the instructions, which are pages and pages long with all sorts of subpoints. But they could, if I'm reading this the way the jury could read it, say that Hernandez directly caused physical injury. That's the first element. That second, the other person, meaning Bradley, was a person who was aware of information, records, whatnot, related to a violation of a criminal statute. That's a very broad standard as to who a so-called witness is. Could be a person who was just aware of information related to the violation of a criminal statute. And third, either, so this is the third element, that the defendant did this willfully with the specific intent to impede, obstruct, or delay, or otherwise interfere with a criminal investigation. That predicates the specific intent, and presumably that an obstruction is, or rather than an investigation is underway. Or there's another element in here that the defendant acted with reckless disregard of the impact that the conduct could have in otherwise impeding, obstructing, or delaying with a criminal proceeding, which also is a pretty broad standard. And I tried to dig in a little bit to the legislative intent behind these things, and apparently they wanted this to be a very broad standard because the legislature presumed that if there were gang-related activities, then it wouldn't necessarily be a clear nexus between the intimidation and the witness and the crime. So they broadened the standard out.
I think what's confusing, I think, first of all, is we don't know how many jurors are asking that question. Secondly, we all seem to be focused, at least I'm focused, which I don't know, we may be looking at it differently, on the word directly or indirectly. And so for my focus, it leads me to believe that the jury is questioning whether or not Mr. Hernandez was the person who fired the shot, since there was questions during the trial about Mr. Bradley writing a text saying he wasn't sure who shot him. That's my focus. Whether I'm correct or not, I don't know. The judge seems obvious in his instructions to the jury now is that you must find that he directly did it because there's no evidence in the trial that indicates there was any indirect, that Mr. Hernandez had someone else do it.
Yeah,
the question becomes, though, whether the jury is asking that or whether the jury is more focused on the two prongs you're talking about, which is the second and the third, and I don't know.
Well, the jury question itself was confusing because it asks the question about the direct or indirect nature of this, but then the question went on to talk about the second and the third prongs of the offense. And the second and third prongs have to do not with direct or indirect, that's in the first prong. So what I was reading into it, and again, I'm just guessing, was that the jury was trying to read the word indirectly to then tie into whether or not a Bradley was a witness because at that point there hadn't been a charge, or there hadn't been a trial, or there hadn't been an investigation that directly pointed at Hernandez. So they're saying, oh, well, maybe that means indirectly. And,
right.
and that's not the way that the elements read through. So that's sort of one way of looking at it. But I agree that your way is another way of looking at it, too.
Well, I also think the statute is a bit confusing. You only see the word directly and indirectly at the top. Mm-hmm. So it's confusing because then when you start to look at the third prong, you start to question again whether the word indirectly or direct should begin the third prong as well. So it's unclear what indirect and direct is referring to when it refers to the third prong, or if it refers to it at all.
I'm wondering if the judge used the actual model jury instructions in this case, or whether the judge used another specific charge that had been cobbled together by the attorneys, because the model instructions would make this a little bit more clear for the jury, because everything's laid out in points that are numbered, and it's easier to wade through them. So I wasn't there to listen to this particular instruction, but this makes it more clear for the jury than perhaps what the jury is trying to hammer out in the jury room.
It's also, they're thrown so much information within a 3-hour period by the judge. So for them, they're basically going through every charge. They may be going from the bottom up. They may be going from the up to the bottom. Who knows specifically who's hung up on what? And again, when these questions are asked, no one knows whether or not it's one juror, the whole jury, who's curious about that specific answer.
Yeah, we had a question on our chat room here, and certainly we're trying to answer as many of as we can get to here. But if I'm understanding the question properly, doesn't the legislative intent have to do with direct or indirect, not with whether or not an investigation was already in progress? Well, it's all of the above, because the three elements of the crime question whether or not the defendant was directly or indirectly causing physical harm. That's the first element. The second element has to do with whether the person harmed was a witness or a person aware of information related to a violation of a criminal statute. Well, in order to be a witness, you have to be called, and there has to have been an investigation, and there has to be a proceeding. That's the first potential prong of the second element. The second potential prong of the second element, so we can say part 2A presumes that there's a proceeding going on, and part 2B presumes that there's a person aware of information about a violation of a criminal statute, a crime, and yet it doesn't presume that a proceeding has been launched yet. So I think that the intent, if I'm guessing it based on the plain language of what I'm reading here, is that it's all of the above. It's that you can intimidate a so-called witness regardless of whether criminal charges have been filed yet. If you know that that quote-unquote witness knows something about a crime that had been committed.
Right. I mean, when you look at we're going to call it 2A and 2B.
Yeah. 2B
obviously is much more all-encompassing than 2A, although 2A indicates that it can be simply a criminal investigation, which isn't one would argue that's not necessarily a proceeding, but still 2B seems to be much broader and encompasses many more situations.
Yes, and so to get to the question again, there's a comment here that, well, if there was no investigation yet, there has to be a not guilty charge. Now, that was a argument that the defense tried, but I don't see that supported in the model jury instructions at all. And I don't see it supported in what little I have read, but what I have indeed read about the legislative intent. If
I don't see that at all, and I think 2B makes that very clear.
And I think that in all of that, whether or not there was an investigation underway is part of the second element of the crime, not the first. The first element has to do with whether there's a direct or an indirect threat. A direct threat would be, causing a physical injury directly. An indirect threat would be, hey, can you go do something to this guy over here? And there would be a middleman.
Right, which the judge says there's no evidence of.
And the judge said there's no evidence of that. So you know, hopefully that clears it up for the jury, and it focuses the jury on the other elements, or ultimately whether or not the jury can believe Bradley, because that's what it all boils down to.
Right. Again, I think this bodes well for the prosecution, but I've been known to be wrong many times regarding this.
So certainly we're digging into any of the other questions that you folks have here, and I'm flipping through the chat room here to see if there's anything else here coming down the line. I'm trying to get to them as quickly as I can. Did we ever figure out who that woman was at the scene, or who they surmised she was? The answer to that, so far as I can tell, is no. There was this insinuation from Warren McMaster, the street sweeper, that he saw someone sticking out of the sunroof of a vehicle, and that person may have been taking photos of the crime scene. That person, assuming that she exists, is off somewhere on an island without the means to communicate. I have seen no evidence. With some of the other
witnesses in this case.
We have no clue who she is, or where she was, or what the, you know, whether or not she was there. There's just nothing. So we do not know if that person exists, and if she does, then nothing went further beyond that. There was just it was used as a presumption that the police should have been approaching her at some point in the investigation, assuming that she was even around to be approached by the police. I believe, if I'm remembering the McMaster's testimony correctly, and if I'm not, then someone out there correct me, that he saw this person immediately after the shots were fired, not when he returned to the scene.
Right.
I think that the street sweeper was there before the police were there, or before they had fully converged. It was so early on that even if there was a police presence when he first encountered the scene, it was minimal, and they were all still converging. So if someone else grabbed a photo of it, then that photo is lost to the ages right now, so far as we can tell.
Look, one would argue that this gives another little piece for Mr. Baez in terms of reasonable doubt, because if you have someone at the scene so close to the shooting, one could argue that perhaps she, or someone who appeared to be a she, is somehow involved in the shooting. It might not be something that sticks with the jury, but certainly that's just another piece that Baez can use to argue that that Bradley is not accurate in regards to his recitation of what happened.
We had a couple other questions coming in here about whether or not why the third guy in the car didn't testify. I don't know. There were additional people in the car. I don't know the answer to that. I'm speculating, but it could just be because that person wasn't available, or couldn't have been found, or something. I don't know why.
I think we had talked about it earlier. We can speculate. We can guess that he went back and made sure he's not to be seen again, based on what happened in the car. If I were him, I might not want to be seen again. Perhaps he didn't have something helpful for the prosecution, so they chose not to put him on the stand. It's not clear.
Any idea why Jaylene or Chicago didn't testify? Good question. I think that it was confusing as to whether or not, as to exactly who those people were. I was trying to guess, and I came up with some guesses, but I think that some of the names here were
thrown out there.
Mm-hmm. They were nicknames, and I don't know if it was ever cleared up fully in the trial as to who they actually were.
And I don't remember the defense getting a missing witness charge, nor do I remember the prosecution regarding any of these witnesses. I know there was some discussion about it, but I don't believe there was.
I don't remember. And that's something I would have to go back and double check myself, because I wasn't here for the reading of all of the volumes of jury instructions. And I had asked the court for some of the documents at one point, but I don't have them all here yet. So, you know, these are all good questions, and I think that this case just leaves so many questions on the table. Who is this person named Chicago? And is that person the person who linked the gun that's presumed to be the murder weapon by the Commonwealth between the scene and the trunk of the car a year later. And it led to another question here about why didn't the defense hop more on the fact that Bradley said the gun was tossed? I don't know. If I were the defense attorney, I would be jumping on that. But, you know, it's tough to try a case and then shift tactics 5 or 6 times on the fly in the middle of it, because I'm sure that Sullivan and Baez and Kenny Bodden had the, you know, some of the closing exhibits and whatnot at least prepared before they went into things. They jumped on a lot, but maybe the dots just weren't connected on the fly. I know that we connected them here, but it was also a part of the case that I was watching closely.
It's also easy for us watching to make judgments in regards to how the defense attorney does or doesn't do. And I was a prosecutor for a long time, and I missed things. Even though I tried not to, I missed things. Perhaps they missed it. Perhaps they didn't think it was the most important argument to be made. Who knows? I think it is a pretty good argument to be made. It just goes to the credibility of Bradley and completely minimizes the prosecution's argument that the gun exists and that someone has it and that it's tied to Mr. Hernandez somehow. But they didn't think it was
I
a big
thought
thing.
that it was the biggest problem in the whole case, but that's just me. And, you know, I guess that if I were the prosecutor, then I would be biting my fingernails trying to figure out how to respond to it, because the prosecution didn't really sum it up. They just said, well, you know, believe this and you know, never mind the man behind the curtain, I think is the way that I took it.
I don't know if I took it that way as much as take him for what he is and decide whether or not, decide whether Aaron Hernandez shot him based on Bradley, but then look at the other circumstances. No witness testifies perfectly, and it's for the jury to make the decision whether or not the other little pieces add up to Bradley telling the truth or not. Do I think it's a big deal that he says he threw out the gun? I think it's a big deal, but...
Well, especially considering the timeline of that's how the Commonwealth of Massachusetts even came to tie Aaron Hernandez into this case in the first place. There's this gun in the back of a car, almost a year. It was within a couple of weeks of when this double murder happened. So the murder happens, a year later this gun shows up in the back of a car, and then they go test the ballistics, and then the ballistics, oh wait, we got the murder weapon from that double murder in Boston last year. And okay, well, I'm surprised we didn't see more of an attack on the ballistics, because that area of science is nowhere near as precise as DNA, first of all. So to say that that's the murder weapon and to then attach the defendant based on striations on bullets is just not really, I mean, it can be done, but it's not really clear-cut science.
But I tend to agree with the defense to not go after it, just because I still don't understand how the gun really being found ties to Hernandez. There seems to be such a distance connection.
The person driving the car grew up in the same town. They didn't even go to the same high school,
Right.
but apparently she hung out with football players, and because she hung out with football players, she must know people who know Aaron Hernandez, and that whole thing gets all muddy, and you
Which
know,
is exactly why
witnesses died, and then it's okay. So they're asking people to believe a whole stack of inferences on top of inferences.
Exactly, which is why if I were the defense attorney, I'm going to say to the jury, how in any way do you get it back to Mr. Hernandez versus the argument that the ballistics just doesn't match? I think the better argument is, so what that it's found in some person who knew someone who knew someone who knew someone who might have known someone who looked like Aaron Hernandez. I mean, it's so distant that if I were the prosecution in this case, I kind of would have hoped that that gun was never found, because I find that part so confusing to this case. I would have rather the jury just be able to focus on on Mr. Bradley.
Well, they have to have something to corroborate everything that Bradley says. So then if you get the jury to believe Bradley, and then you get the jury to believe the gun thing, then, well, maybe that's corroboration.
But I think that it hurts them, because then we go back to the argument that Bradley said the gun was thrown out the window. So it was thrown out the window. How would it have ended up in the hands of someone that sort of, kind of knew of someone who kind of was Aaron Hernandez? I mean, it just doesn't work.
Yeah. I mean, I have been meaning to, and forgive me, folks, that I've been trying to write everything else. I really wanted to go back over this thing once I started to figure out the issues with the gun and pluck out all of the quotes in the testimony and try to call this thing the immaculately conceived gun or something like that, because it's such a convoluted chain of custody that it raises questions. If you believe Bradley, then you've got to probably believe that the gun that the prosecution is showing off in court isn't the murder weapon, and if you believe that that's the murder weapon, you can't believe Bradley. So what is it?
But I guess here's my question for you is, do you believe that someone in that car shot those two people? Do you believe that? I mean, do you believe that? Because Mr. Bradley is saying that it was either him or Hernandez. He's saying it's Hernandez.
Well, he's saying it's Hernandez. The defense is saying that it's...
the defense is saying it's him. So why would he say, so do you believe that is correct, that Hernandez and Bradley were in a car and that someone shot that gun from that car? Or do you think it just had nothing to do with Hernandez and Bradley? Because if you believe for a second that Bradley is telling the truth, that it happened from that car, there's an argument to be made from the jury that they don't care who shot him. They just know that if Bradley was in the car and Hernandez was in the car, they're both responsible, and then therefore Hernandez is responsible, and too bad that Bradley got away with it. Do you know what I'm saying?
Yeah, that's
like
not a
more simplistic version of this is, who cares about anything else other than, did those two people in the car, you know, they don't care necessarily who did it, as long as someone from that car did it, they're going to be held responsible.
And we're getting some comments in the chat feed about the connection of the gun to the trunk, and I was actually not here for the first week of testimony, so I didn't hear the whole thing. But the bottom line is, okay, it's you know, Sherry, you're saying that the girl who was driving the car was dating somebody's nephew, but again, I don't know all the names of the people to indicate the chain of custody, but again, so somebody's dating somebody who's got access to somebody else. That doesn't, then who got the gun off the side of the highway and then changed it from one type of gun to another to magically turn it into this kind of gun?
But Bradley might just be mistaken about that one thing.
Well, if he's mistaken about that, what else is he mistaken about?
Well, there's a difference between being mistaken about a gun being thrown out a window and who the person is that shot and killed someone in front of your own eyes. There's quite a difference between those. That doesn't mean he's telling the truth, but there's an argument to be made that he's just simply making a mistake about that.
It's an imponderable that one of these days, like I said, if I had a week to go back over the testimony and to pluck out exactly how they claim that this thing got from point A to point Z, then I still think that even if we knew everybody whose hands touch that gun, it would still be convoluted. Sure. And that's the Commonwealth's job, to explain all that. If they want to get up in court and point this thing around and parade it around and call all these forensics experts, then they better explain to me how it got from the murder scene to the courtroom.
Although there is additional evidence from the girlfriend talking about a gun being in the house, and that's still kind of murky and kind of falls into all of this also. Was that the murder weapon? Was that not the murder weapon? So that kind of fits into, or I'll say doesn't fit in, to kind of this whole story.
Yeah, I mean, there are a lot of inferences piled on top of inferences here. We had another question about 7 minutes ago, and I want to get to this one. Thoughts on Sullivan's argument of Hagen's wording? So the defense's complaint about the prosecution's wording in closing that the tattoo was, quote, confession. I think the judge didn't want that to go there, if I'm remembering that properly, and it was... I wasn't really comfortable with that personally, that language, but I think that, was this a game of the prosecutor saying it and then waiting to see if there was an objection, and then the judge will turn around and say, well, disregard that, but the seed has already been planted?
Well, the first question one has to ask is, why was it let in the first place? If it was let in as some indication that he had committed this crime, then isn't that what a confession is? Like, what is the relevance of the tattoo coming in other than it being indicative of him having committed that crime?
Well, I think that there's an argument over what the legal standard is for a confession. I mean, in law, a confession isn't just an "I did this." it's coupled to the premise that the defendant is literally giving himself up to the authorities. It's a surrender more, or the confession, the legal standard for a confession is more of a surrender than it is a per se confession.
But I think there's a fine line with the purpose of the tattoo coming in is to say that somehow he put that out there on his body because he was either taking pride in it or wanted some acknowledgement about something he had done. But something he had done, meaning he had committed a crime.
But it doesn't say, I confess to killing these people. It results in additional inference drawing and speculation perhaps and dot connecting. It's not a confession. He didn't sit down and tell the tattoo artist, draw on my arm that I shot and killed 2 people in Boston.
I understand that, but the reason it's coming in is as further proof that he committed the crime, and so therefore we're using the word confession, and perhaps I think there's a fine line between the word confession and there's an admission going on his arm. I think so. I think that's the reason it came in the first place.
But it's not necessarily a confession. It's a picture of a gun with 5 bullets in the chamber, and if you believe that only 5 bullets were fired, then maybe there is a tenuous thread between the tattoo and the testimony.
I don't think it's so tenuous if it's done after the crime. I think it's pretty clear. If you believe that 5 shots were fired on that day and he decides after the incident to put a tattoo on his body that has 5 shots being fired, then I think that's pretty clear that I would argue that it has everything to do with this case. I hear you.
I think that, look, I mean, I've seen cases with stronger evidence than this.
Well, I think we both agree that we've seen cases that are much stronger than this case.
And you know, I'm a little bit more keyed into this notion of what the legal concept of a confession is, because I'm the one that, when I was a journalist covering the Stephen Avery trial that everybody knows as the Making a Murderer case, I'm the one that sat there in front of the prosecutor saying there's been a confession, and then a year goes by before we even see the tapes, and then we're sitting there saying, well, is that really a confession? And then we have a federal judge saying that's not a confession because the standard for what legally counts as a confession is pretty high. Mm-hmm. It seems to me that prosecutors want to think everything's a confession. And the federal appellate court in the Dassey case points out that, you know, and of course that's on appeal now too, and sure, some people, including one of my former colleagues who covered the case along with me, has said that the appellate court broadened out the standard unnecessarily, but it led me to do a lot of research into what the law counts as a confession, and it's really a giving yourself up to the authorities. But I surrender.
But there's arguments. There's also arguments that simply silence can be an admission of guilt, or you know, when someone says something to you and you fail to speak, that can be considered an admission. So there's different ways that someone can admit to conduct without it being an actual surrender to authorities.
It could be, and we could keep beating that issue to death for quite a while here, but hopefully to give some fodder to discuss here. So another question popped up, and I'm actually writing about this right now. I spent half of last night and then most of this morning writing about this assertion that the judge's decision to select a white woman as a foreperson, will that gain any traction on appeal if there's a conviction? The answer is the lawyerly maybe, which is always the cheap way out. But here's the thing. I think Sullivan went way too far in trying to attach a racist motive to the judge's decision. But I know why he did it. He did it because there's a Massachusetts Supreme Court case that actually considers the inverse of what happened in Hernandez. Apparently there was some case back a while ago, and let me see if 1985, Commonwealth versus Campbell, where a judge actually did let a jury select its own foreperson, And the defendant appealed that because the Massachusetts criminal trial procedure rules state that the judge has to select the foreperson before the alternates are pulled out. So there's a couple of moving parts to this. First of all, Judge Locke did exactly what the trial procedure rules told him he had to do. And yet Sullivan objected to that on constitutional grounds, said that it's a violation of the Due Process Clause. In order to lodge that objection, I think Sullivan automatically had to inject a racist or a racial charge into that argument, because in the Campbell decision, the court states that, and that's the decision from 1985 that examined basically the inverse of Hernandez. The court stated that in order to object to a, where's the right word here? Irregularity in the jury impaneling. In order to object to an irregularity in the jury impaneling process, the defendant has to prove some degree of prejudice, that the defendant suffered prejudice by the irregularity. It's on page 84 of the Campbell decision. So that's probably what Sullivan was attempting to inject into the record. But the problem is that the problem that I saw in the whole argument that bothered me, and you tell me whether you agree, is that there's a way to make the argument without resulting in an ad hominem attack on the judge, and then the judge resulting in a straw man attack back on the defense. So the judge and Sullivan are arguing at one another, and Sullivan's attacking the judge, not the rule. Sullivan doesn't point to the rule and say, I've got a problem with this rule, and then the judge doesn't point to the rule in defending himself. And instead creates this straw man argument to try to make it look like Sullivan's playing the card rather than attacking the rule. Here's the bottom line. I've got a problem when in a court of law we start attacking one another rather than discuss the actual rule that's up for debate.
Well, there's an argument to be made, though, that Sullivan has to attack the judge because he can argue that the rule is no good, but in order to argue the aspect of racism, which I think what he's doing is obviously preserving the record, is he has to attack Locke's decision to pick a white woman. And so the only way to do that is to attack Locke. And so Locke's natural response should be that this is what the rule is. And then obviously in this situation, Locke took it personally that he would, that as an affront to him, that he would pick a white juror for any other reason other than his position, which was that seemed to be the juror that was the most attentive, and that's who he felt should be the juror of choice.
Yeah, but the Locke didn't defend himself by pointing to this rule. He could have pointed right to this rule, and instead he just said, well, that's the way I've always done it.
But one of the arguments...
That's not an argument.
No, I agree with you. And one of the arguments also is that he told the jurors from the start that they would all have a chance to be on the jury. And so by picking a juror beforehand, in a sense, he wasn't really following through with that to the jury as well, because he picked someone and that person was no longer... That person was basically immune from not being on the jury. I find the Boston choosing of jury bizarre to me, just because New York does it so different.
Yes.
And I like our system much better, and I don't think any of this would have happened in a New York jury.
Okay, let me finish this discussion up really quickly. I'll go on the record and say the following. I would agree with Sullivan's premise that this Massachusetts system just doesn't pass the fairness smell test. I agree with that. My issue is that I think that the objection could have been lodged with a heck of a lot more citation to the record.
Sure.
And I know that some appellate courts will say, well, if you didn't fully argue your objection with some specifics, like a law review article, like the studies about whether or not the judge's selection of a foreperson can influence the rest of the jury, stuff like that, which I was able to find in about 3 seconds. If you're not objecting with strong, fully developed arguments, then your objection's moot. So I think Sullivan was on the right track, but he derailed, and then the way the judge responded to it, he went off his track. So you got a multiple train derailment going on here. So
I also think he should have done it sooner. I'm surprised he waited so long to make.
Yeah, the judge waited until he was the accusation was levied on Thursday. The judge responded to it on Monday when he felt he had time. That's Friday, Saturday, and Sunday. That's 3 days to get your ducks in a row, Judge, and say I'm you know, disagreeing with you, and this is the reason why, because Rule 20 sub D sub 2 says that's the way I have to do it.
Which I'm surprised he didn't do that. That's not like him, considering how he's been throughout this trial.
Yeah, so I think that he probably took it more as a personal affront than not, and maybe that knocked him off his game a little bit. But anyway, we want to bring Cathy Russon in, and I think that she's got some insight into this jury instruction issue this morning. She's with courtchatter.com, and we are going to go to her as soon as we can get to her, because she spent some time going over the actual jury instruction this morning, and she said that she was standing by and that she's ready to talk to us. So here's what we're going to do. We're going to listen to a little bit more of the prosecution's arguments in this case, and we'll dial Cathy in, and we'll be right back with her insight in just a couple of minutes.
It is often said that a picture tells a story. And each and every one of you now know the terrible, the violent, and senseless story that these 4 pictures show. 2 men's lifeless bodies covered in sheets. Daniel D'Abreu and Safiro Furtado. 2 men who you know did nothing wrong that night. 2 men who you know, despite baseless allegations from a defense attorney, were doing nothing wrong that night. They were doing nothing wrong when they were brutally murdered and killed. 2 men who were not drug dealers, drug addicts, gun-toting gang members. You now know from the evidence that these were 2 men, hard-working immigrants to this country, who were out for a night with their friends to have a good time, who were set upon by a killer who was motivated by an illogical, senseless belief of being disrespected, being tried. A belief that will never, ever, no matter how long this trial were to go, no matter how many pieces of evidence we put before you, it would never make sense, because you cannot fully climb into the mind of a killer. Ladies and gentlemen, this car, these pictures of what was in that car, the carnage in that car, speaks volumes. It speaks a story. Their bodies pierced by 5 devastatingly accurate and deadly gunshots. But you now know from the evidence that not only 5 shots were intended to be fired by that killer. That killer took pleasure in what he did that night. That killer wanted his victims to see it coming. He called their names. And if there's one thing you can take from the know-it-all Dr. Downs, you can take the fact that we agree with his assessment that Safiro Furtado was looking at the shots as they were coming, looking down the barrel of a gun held by a murderer, because that killer wanted him to see it coming. These photographs, ladies and gentlemen, they speak to murder in the first degree and nothing less. 5 bullets shot into that car, killing those men, but more pulls of the trigger than 5. The killer wanted more carnage in that car. He continued to pull the trigger, but the gun was empty. Each pull of that trigger, ladies and gentlemen, think about it. To think, to pull the trigger, to hear the shot, to pull the trigger again, to hear the shot, to know, particularly when you were driving home, that you got one in the head and one in the chest. The killer knew that. Ladies and gentlemen, that screams intent to kill. That screams deliberate premeditation. That screams, these photos scream the crime here and nothing less, murder in the first degree. Safiro Furtado, we don't dispute the fact that he was killed instantly. 2 kill shots fired by that man's gun right into his head killed him instantly. But that does not change the fact that he was killed with deliberate premeditation with an intent to kill. It's a different story with Daniel D'Abreu. You now know from the evidence how he died. And let's think about that for a moment, how Daniel D'Abreu died. 2 gunshots to his chest, gunshots ripped through his lungs, through his heart. His chest cavity began to fill up with blood. He breathed in blood. You heard that testimony from the medical examiner. And even though the celebrity know-it-all Dr. Downs says, oh no, he would be unconscious within seconds, Dr. Downs wasn't there. But Rashidi Sanchez was there. Donald Gobin was there. Brian Kwan was there. Rashidi Sanchez told you that he was not unconscious. Rashidi Sanchez told you what his last moments were like. He was trying to speak. He was conscious. He was laboring to breathe, and then he expired. Seconds, 10 seconds, or 60 seconds. Doesn't really matter when you think about the way that he died. 10 seconds. That was 10 seconds, ladies and gentlemen. So does it really matter whether it was 10 seconds that he lived or was conscious, or 60? He was suffering when he died. And I don't tell you that to upset you. I don't tell you that to shock you. I don't tell you that, as Mr. Baez said, to make you angry. I tell you that because when you hear Judge Locke's instructions later on this afternoon, you will realize it's important. It's important to know how Daniel D'Abreu died. It's important to know whether or not he suffered. It's important to know whether or not the killer took pleasure in the deeds that he had done. Because, ladies and gentlemen, that will be the definition of extreme atrocity or cruelty. A murder committed with extreme atrocity or cruelty, which soon you will know from Justice Locke means murder in the first degree. That's perhaps the easiest part of your deliberations, what the crime is here. Murder in the first degree by deliberate premeditation of both victims, and murder in the first degree by deliberate premeditation and extreme atrocity or cruelty for Daniel D'Abreu. Ladies and gentlemen, about 7 weeks ago, each and every one of you were summoned to jury duty. It was the week of February 14th. There was a snowstorm on the 13th. The court was canceled. Each and every one of you came in and sat through a rather long selection process to become jurors. And at that time, you knew nothing about this case. About a week later, you were sworn in as jurors. You were chosen by the sides, by agreement, because each and every one of you could be fair, impartial, and objective. Each and every one of you would give this case the attention that it deserves. And you've held that bargain, or you've held that obligation amazingly so. No sick days for you. You were here on time every single day, and as Mr. Baez said, both parties appreciate that. When you came in and the evidence began, you were sworn as jurors. You still knew very little about the case. A few days later, you went on a view. You stood in the very spot where Daniel D'Abreu and Safiro Furtado's life literally drained out of their bodies. Stuck in that car, trapped, nowhere to run from the killer's bullets. You stood in the spot where it all began. You stood in Club Cure. You walked around Club Cure. You walked to the parking garage. You went all around the area. You actually stood in the spot where the killer car saw the victims and set upon its prey. That was the view. You still knew very little then, ladies and gentlemen. Here we are, 5 weeks later, 70 witnesses later, almost 400 exhibits later. Now you know the truth. Not from anything I say or what Mr. Baez says. You know the truth from the evidence in this case, which speaks loudly and it speaks clearly. You now know the truth of who the killer was that night on July 16, 2012. You also know that that senseless violence did not end on July 16, 2012, but that violence continued 6 months later when the same perpetrator unleashed the same type of violence on the only man who could tell his vicious, awful secret, his former best friend, Alexander Bradley. And ladies and gentlemen, you now know from the evidence that the killer who I speak of sits right before you, Aaron Hernandez. Now you just heard Mr. Baez's closing argument, much like his opening. Very well said. But think about what Mr. Baez said and think about the evidence and how much of what he said was actually supported by the evidence that you heard. And a lot of Mr. Baez's closing argument was about Alexander Bradley, and that's fine. I want to talk about Alexander Bradley with you. But before we do that, just bear with me. I want you to consider, ladies and gentlemen, as if you heard this case and did not hear one word of evidence or testimony from Alexander Bradley about the events of July 16, 2012. What if you only heard evidence from other sources? And what if the only thing you knew from Alexander Bradley came from his presumptive lawsuit he filed for being shot in the face? That's it. Bear with me. Let's go through that evidence if we can. The car. Is there really any doubt what the murder car was in this case? Did Mr. Baez even dispute that just now in his closing argument? Who had the best view of what the murder car was? Donald Gobin and Brian Kwan, right here on Marginal Street. You were there during the viewing. A block away, the silver SUV pulled up right next to them. Brian Kwan, Donald Gobin, they both got a great look at the car. Donald Gobin in particular knows cars. He actually said that night either a Toyota 4Runner or a Nissan Pathfinder, Rhode Island plates. That was said that night.
Differences from the evidence, but neither counsel nor you, during your deliberations, may speculate. You may draw reasonable inferences, but you may not speculate or engage in conjecture. And as it relates to the evidence presented in this case, please understand there is no evidence showing that the defendant, Mr. Hernandez, directed anyone at 114 Lake Ave or anywhere else to move a gun in or around June of 2013. And to conclude that the defendant directed someone to do so would be engaging in speculation. That would not be permitted. Mr. Hagan, please.
Thank you, Your Honor. So as I stated, Aaron Hernandez, the defendant, you can connect him to the murder car, not Alexander Bradley. Aaron Hernandez, you can connect to the murder weapon, not Alexander Bradley. But there's more. Interactions with the victim.
Okay, folks, we're going to dip out of the discussion that we were listening to, a replay of some of the prosecution's closing there, and we're going to go to Cathy Russon from courtchatter.com, and I wanted to punctuate that, and apparently I've been saying your name wrong, Cathy, and so you have my apologies.
Thank you, Aaron. How are you?
I'm good, and I will admit that old habits are hard to break. There is a restaurant where I grew up that is pronounced the way I've been pronouncing your name, and so I just relapsed into what was known to me rather than to what was correct, so I will correct myself now and apologize to your followers who are skewering me because of it. So I make no vouching as to the restaurant beyond the fact that the name is pronounced the way that I've been saying your name, but apparently that's humorous to people, so I'm glad that I was able to be the recipient of their humor. I'll just put it that way. So anyway, you've been...
I love the Court Chatter followers.
You have been, and we're here with Julie Rendelman, who's joining us in our studios in New York. So let's talk about what you've gone through with this response to the jury question this morning.
Yeah, so the witness intimidation, I'm just going to pull it up here. I was confused with what their question question may mean, we have to read tea leaves, obviously. So I went back and listened to Judge Locke's instruction on the witness intimidation charge, and listened and re-listened, and I typed up how he instructed them, and then I tweeted that out if people want to go back and read it. And then I heard you guys talking about that earlier, so I wanted to come on and discuss it a little bit. No wonder they're confused, is what I have to say. So there's 3 elements to the witness intimidation charge. And number 1 is that the defendant directly or indirectly willfully threatened or attempted to cause physical injury to Alexander Bradley. Now, on that first element, it says, Commonwealth must satisfy you beyond a reasonable doubt that the defendant shot Alexander Bradley. So right there, that seems to be some source of conflict, that the defendant directly or indirectly, willfully threatened or attempted to cause physical injury, yet the Commonwealth must satisfy you beyond a reasonable doubt that he did shoot him. So I don't know why it has to say directly or indirectly. At the same time, they have to prove beyond a reasonable doubt that he did do it, that he did shoot him. So he had to have physically shot him, not somebody else.
I think that, well, as to the conflict between the indictment and the instruction, I'm assuming that the issue is that, as to that the indictment was written before all the evidence was brought into play, and the instruction was written after most of it had been brought into play. Do you agree, Julie?
No.
And a lot of times the instructions are much more limited to the evidence presented than the indictments.
Right. I mean, the only evidence of the intimidation is the shooting. Mm-hmm. There really wasn't.
I completely agree with that, okay? So I get it. I get it. But the jurors have these instructions in front of them, and this is their only instruction. So as to the first thing, it says one thing, and then it says the other thing. I think that's where their confusion is coming in. And this is really what they have. And then, and there's 3 elements. So then the second one is that Alexander Bradley was either a witness or a potential witness, and you guys were talking about this earlier, at any stage in a criminal investigation, and it goes on. And that element, the Commonwealth must prove that Alexander Bradley was a witness or a potential witness to a criminal investigation or proceeding. And then this is the answer to what you guys were talking about earlier. The Commonwealth does not have to prove that Alexander Bradley actually provided information to the police at the time of injury. Mm-hmm. So he doesn't have to have given them any information at that time. And then the third one is the defendant did so with specific intent to impede, delay, obstruct, harm, punish, or otherwise interfere with the criminal proceeding. And that element is the Commonwealth must prove beyond a reasonable doubt that the defendant's conduct in injuring or attempting to injure Bradley was committed with specific intent to impede, all the other words, with a criminal investigation that requires the Commonwealth to prove the defendant's purpose in shooting Alexander Bradley was to prevent him from providing information to law enforcement regarding the shooting deaths of Daniel De Abreu and Sofrio Furtado. The defendant must have specifically intended to impede, obstruct, delay, and interfere with the investigation of these shootings. Now here's the bottom line for me. At the very bottom, the very end of his instruction on this particular witness intimidation charge, Judge Locke says, if the Commonwealth proved he shot, the defendant shot Alexander Bradley, but failed to prove he shot him to impede the investigation, then they have not proved the crime of witness intimidation. So they can believe that Aaron Hernandez shot Bradley, but if the Commonwealth did not prove that the reason he shot him was to impede the investigation, then he has to be found not guilty on that charge.
Which makes perfect sense.
And then if the Commonwealth fails to prove 1 or 2 of those 3 elements, then the verdict also has to be not guilty. So they have to prove all 3 of those elements. and that, I think that's why obviously that's why they asked about the confusion, if they believe that, about the directly or indirectly. They said, you know, here you say directly or indirectly, but down in the explanation you say something different.
It's an interesting instruction, because if I were the prosecutor, I probably would have been shoving a lot harder for more language about the reckless disregard of impact.
And there's nothing about that at all.
Well, did they choose that theory initially? Is that how does the indictment read? I don't know if they had already been stuck with that. Because
we have the indictment too for the witness intimidation. I have that.
Because it sounds like they went with, when we were talking about 2A or 2B, they're with 2A, which is less broad than 2B in regards to that first part, and then the third part, they're going with the other one as well.
Yeah, I mean, if that's the case, then the indictment was too limited. I'm going to have to go back and match up these model jury instructions with the actual statute, which I was trying to do the other day. Let me see.
I looked at the model instructions also that I found online, and then went through and exactly word for word of what Judge Locke read out, and you know, it's not exactly what those model instructions were. Obviously, it's tailored more to this.
Yeah, Julie, what's your experience in New York? Because the trials that I've sat in on in New York really don't deviate from the model instructions, for the specific reason of them being a lot of attorneys just agree to go with the model instructions so that there's not any wiggle room.
Many judges will just go with the model instructions. Many judges will incorporate certain lines from the defense attorney and from the prosecution based on the facts of this case, along with whatever new case law has come out that kind of may change the way the jury instructions read. Every judge is different, but it really depends on the circumstances of the specific case. Cathy, does the indictment for that, the charge for that specific, the intimidation, how does it read on the indictment?
I'll pull it up right now. So the indictment,
which I did have in front of me, but I no longer do.
I did too, but as soon as we're asked to do that on camera.
Sorry, I'm doing that
I've got probably 30 tabs open on my computer right now, trying to shuffle between all these.
Grand jury indictment. All right. Well, it's very short, so I'll just read it.
Oh.
The indictment is that on February 13th, 2013, Aaron Hernandez did directly or indirectly, willfully threaten or attempt or cause physical injury, emotional injury, economic injury, or property damage to another person, to wit, Alexander Bradley, who is a witness or potential witness at any stage of a criminal investigation, grand jury proceeding, trial, or other criminal proceeding of any type, or a person who is or was aware of information, records, documents, or objects that relate to a violation
So it's the whole thing.
criminal statute, or a violation of condition of probation, parole, or bail, with the intent to impede, obstruct, delay, harm, punish, or otherwise interfere thereby, or do so with reckless disregard with such a proceeding.
So incorporate.
So I probably would have been pushing for a much more broad reading of that indictment in my jury instructions, if it were me. What do you think? Agree, disagree?
I'm still tied up on what they're asking, so I don't, to me, it would, if the only issue they have is whether he's the shooter or not, then it doesn't really make a difference. But if
I don't even think they're asking about that. So do you have the exact wording of the question in front of you, Aaron?
I have the first part of it.
The first part.
Because it went on and on and on, and I went back and listened to it a couple of times.
One of my moderators are listening. I know they'll have the exact question. Because...
Give me just a second. I have the first part of it. And of course I'm trying to jump between three different... The first part of it, quote, "We aren't sure if the defendant can be found guilty, if we find he indirectly, willfully threatened or attempted or caused physical injury to Alexander Bradley.
Okay, so if we find that he indirectly...
Let me send it to you too, Kathy, so you can mull over it. Now, the thing went on to reference the second and third counts.
Right, but then, okay, right, but then they reference the second and third elements, I think.
Yes, which is odd because the word indirectly appears in the first element.
Right. That's why it's almost like they are confused at what they are asking.
What indirect applies to.
Mm-hmm.
Right.
Which is why I was trying to weed through it and say, okay, maybe they're trying to read the word indirectly to mean...
If anyone wants to follow, by the way, if you just go on Court Chatter and click on the Aaron Hernandez archive, I typed up this witness intimidation instruction. It's on there on a PDF in his archive page, and the grand jury indictment is there too. You can pull them up side by side if you want to look at the wording, and you can just, instead of just, you know, a lot of us watching us read this, you can also be reading it yourself.
Yes, we have those, and I'll send out in our chat room the link to the jury instruction, so that to your link, so everyone who's watching us and watching you can all be looking at the same thing. I was thinking that the jury was getting lost in the weeds between the first and the second and the third elements, and that they were trying to read the word indirectly into the other elements and saying, okay, well, maybe it's indirect intimidation if in theory Hernandez shoots Bradley without there being an investigation launched yet. Or maybe they were trying to say this is indirect intimidation because because Hernandez didn't directly say why he was shooting Bradley, but he directly pulled the trigger.
Right.
In which case, that's muddying up the language of the statute. In other words, can he read into, can we presume the state of mind as an indirect intimidation, even though that's really part of the third element in specific intent?
Right. Well, there has to be proof that the reason he did it was to do some type of intimidation. If not, it's just simply him shooting him without more. I mean, then it would just be a simple assault case.
Because, you know, it was the night before that supposedly Bradley made the comment to Hernandez about, well, that's, you know, it's probably about what you did last summer in Boston. You know, that was 24 hours before that he made that comment. Which is how they're trying to tie this.
Right, they're linking that to be to establish to the jury that establishes witness intimidation because he was doing it because of that statement he made and for no other reason.
Mm-hmm.
Right, and then Bradley says on the stand he doesn't know why Hernandez shot him.
Right, which is an even bigger problem. Especially if you're intimidating someone, you would expect that the person who gets shot would know why they're being shot, and even he doesn't know.
Yeah,
that's the point of intimidating somebody.
Well,
yeah, I mean, you know,
maybe
we can beat this to death, which is what we do during verdict watch. This is what we all do. This is what the
jury's doing. The jury's sitting here.
And then we'll talk. You know, we'll talk to a juror afterwards, and we'll probably be completely off base with what they were thinking. But
the jury's sitting here doing the same thing we are. They're bringing up the same pieces of information, and you know, thankfully, in this case, the jury has the copies of the instructions back there because I had to serve on a jury once years ago, and I didn't have copies of any of this, so we're trying to remember in the jury room what the elements of the charge were, and we kept having to go out and have the judge reread them.
But you know, I hate to say this, but even we have it in front of us and we're still a bit confused. So, you know, one wonders how the jury's doing with that because there's still certain things that aren't defined, and still the way it separates out is still confusing about where the word indirectly and directly applies. So even having it can be confusing.
And remember, these 12 people are just citizens who don't necessarily get involved in the law or cases or watching trials or have never read wording like this before. You know, this has to be very confusing for them.
Yes, it was confusing for me when I served on a jury, and it was long before I had gone to law school, but I took enough of a concentration of law as an undergrad student to at least have somewhat of a sense of what was going on, and it was still lost. To try to hear all this verbally and to try to match up the testimony with the language that's given in the statutes is daunting, and it's even more daunting when faced with lapses in memory. You know, we have these discussions off the air all the time, Cathy, and I'll say, wait a minute, did he say that or not? And then you'll remember it, and I say, I didn't remember when he said that. And I would hate to be in the position of the jurors trying to remember every piece of testimony over a trial that lasts a month. It's
right.
tough.
I mean, it's awful. I mean, that's why I go back in the archives and I'm constantly re-listening to things, because you miss it all the time. And jurors are taking notes, but how many notes could you possibly take like that? And they're not really necessarily tuned into certain things like the rest of us are, because we've been doing this so long.
Yeah, this one has been tough because the links are so convoluted. I was going to say tenuous, but you disagreed with that. So they're so convoluted that I have to go back, and I've re-listened to some of the testimony 2 or 3 times to even try to keep track of who said what. Well, wait a minute, did she say that happened here or here? And then all of a sudden it becomes relevant 2 weeks later. So yeah, I feel bad for the members of the jury trying to weed through this. So I was sort of wondering if they were winding down here because this is one of the last charges, if not the last charge on the indictment. But you know, they might be going for quite some time with this.
I would think that they have gotten through the rest and are stuck on this. That's my opinion. I don't know why they would have started with this. That doesn't make a lot of sense to me. But
well,
maybe they started with Bradley's testimony, his credibility, all of that, since he's the key to all of this. So maybe they started with that, and that's what they've been arguing over. I don't know.
Although the only way to really get to that is the only way to get to witness intimidation is if they found him guilty of the murder charges. Although jurors are funny, a lot of jurors, sometimes there's so much stuff in front of them, they're like, let's just go down to the easy one and start with that. And so who knows what they're doing.
Yeah, well, right, but you can't, how can you talk about witness intimidation, because what did he witness?
Exactly.
It almost has to be the last thing you talk about.
I agree.
So I would think that they're close. You know, I love reading the tea leaves of things like, are the jurors dressed up? Oh, a juror got a haircut today. That's one thing we learned. So, you know, you think things like that. We always look at that. Did they expect to be on camera today? Who knows? And
then also, I hate to repeat this, but again, we go back to, it could be one juror that just looked ahead and said, you know what, I have a question about that last charge, and then they had to ask that question. So who knows if it's everyone asking those questions.
Yeah, you know, and we just had the Dalia DiPolito trial not too long ago, and we kept saying, oh, there's that one juror that's hung up, it's that one juror. Turns out that was a split of 3-3 in that mistrial. Mm-hmm. So you really don't even know about one juror has a question. No, who knows what's going on in there.
Yeah, so here's the bottom line. I mean, they should be coming back from lunch around now. This is when they usually do things. And we're hearing that the judge is got his robe back on, but he apparently also is there to hear another case. So there must be some other hearing that he has to go and attend to, so it may just be because of that. So we continue to monitor things in the courtroom. Did you have any other epiphanies, Cathy, while we still have you here, or are you about tapped out for the day trying to figure this one out?
No, but they did have the question, I think, and you addressed it earlier, but my chat room was also asking about the third victim in the back seat, and it's Gerson Lopez, and I think I'm going to destroy that.
Don't mispronounce a last name, Cathy. Don't do that.
Hey, listen, Aaron. He survived. He was never even hit with any gunfire. And really, we have asked and asked and asked, and I have asked anyone and everyone, and the general consensus is he's probably back in his home country, and that's why he was never called as a witness. He never testified at a pretrial hearing, and he hasn't testified in this trial, and that's pretty much the only answer that I can get.
So he got out of town
He's in the wind.
Yeah.
Yeah. Yeah.
I had assumed that the witness was probably unavailable for some reason, but that would count.
One can only imagine what he would have said had he taken the stand.
Yeah. So.
Well, yeah. This is one. Remember, he ran off with Sanchez. They took off that night, the two of them. So it would have been very interesting to hear from him. But he's gone.
Well, Cathy Russon, I appreciate your insights, and I'm glad that I've been corrected after a couple of times here. So you should have yelled at me sooner.
Oh, my last name gets mispronounced all the time.
Well, it's my fault, and I should have known better. So I appreciate your forgiveness, and we'll talk to you again soon.
Okay, thank you.
Okay. Well, Julie, we're waiting for the lunch break to end here, and anybody could guess as to when this deliberation is going to end, but it could just keep going on and on and on.
Yeah, we could be here for a long, long, long time.
Well, the good news is that we are also paying attention to the Stephen Jones case, but they're not coming back into deliberations until Thursday. So that's that's another one that we're keeping track of as well, and that one I think is got a lot of issues with characterization as well. So we're waiting. I'm getting word that the court reporter is in the Hernandez room, the courtroom. So let's wait and see what's going on here, because there might be something coming down the pike. But we'll keep an eye on it there in the courtroom and see what's going on, just in case there's another question or something along those. Well, apparently it's a status conference for a different case. So apparently they just have to double up on the use of that courtroom. So, but we'll continue to monitor it. Julie, I think you have to run now, right? It's about 2 o'clock. So we appreciate you coming in.
Thank you for having me.
And let's go back and listen to a little bit more of Patrick Hagan's closing, which we had started to play for you a little bit earlier on.